Alright, welcome back to the channel. In this video, I'm going to look at how the feds were able to force integration on states that didn't want to have or become desegregated, I guess you could say. Now, we're not really going to be looking at the moral implications of segregation or desegregation, but more just to look at what mechanisms and laws were used by the federal government to enforce their will onto states that didn't want to. And now people are saying that the states' rights thing is similar to marijuana legalization, but I beg to differ because of the fact that there's no part of the Constitution that says that the government can tell you what to eat or drink. But we'll just check just to make sure. No part of the Constitution explicitly allows the federal government to directly tell individuals what they can or cannot eat or drink in their personal consumption. The federal government does regulate food, drugs, beverages, and related products extensively. Congress shall have the power to regulate commerce with foreign nations and among several states and within the Indian tribes. This clause gives Congress authority over interstate commerce. Federal laws like the Federal Food, Drug, and Cosmetic Act, building on the 1906 Pure Food and Drug Act, prohibit the manufacture or sales or shipment in interstate commerce of adulterated, misbranded, unsafe, or otherwise prohibited food, drugs, or beverages. Banning or restricting interstate sales of certain unsafe additives, contaminated products, or unapproved substances. Regulating labeling, safety standards, and recalls for food and drink that moves across state lines. Supreme Court has interpreted the Commerce Clause very broadly, especially since 1930 to 1940. In some cases, allowing regulation of activities that substantially affect interstate commerce, even if the activity occurs within one state, because individual actions in aggregate impact the national market. For alcohol specifically, after Prohibition ended, the 21st Amendment gives states broad power to regulate importation, sale, and use of alcohol within their borders, while federal regulation still applies to interstate aspects. That's important, interstate. In short, the federal government cannot constitutionally force you personally to eat broccoli or forbid you from drinking soda at home as a direct mandate on private conduct. It can and does heavily regulate the production, labeling, safety, and interstate sale and distribution of almost everything you can buy to eat or drink, justified under the Commerce Clause. If a law tried to outright ban personal consumption of a common food or drink without a strong tie to commerce or another enumerated power, it would likely face serious constitutional challenges. Most existing federal rules focus on commerce, safety, and fraud prevention rather than dictating personal diets. Okay. Brown versus the Board of Education, 1954, the Supreme Court ruled that state laws requiring or permitting racial segregation in public schools violated the Equal Protection Clause and the 14th Amendment of the Constitution. This declared segregation unconstitutional but initially ordered desegregation with all deliberate speed, leading to widespread resistance. Federal courts, district and appellate, later issued specific orders in individual cases, sometimes mandating remedies like busing, redrawing attendance zones, or faculty reassignment. The Supreme Court affirmed federal authority to enforce these cases in cases like Cooper v. Aaron. Okay, the Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, or national origin in any program or activity receiving federal financial assistance. Public schools in the South dependent on federal funds. The U.S. Department of Health, Education, and Welfare could withhold or terminate federal funding from non-compliant districts. This created strong financial pressure. Districts had to submit desegregation plans acceptable to the federal government or risk losing money. It dramatically accelerated integration in the late 1960s and early 1970s as many southern districts complied to avoid defunding. Okay, the Elementary and Secondary Education Act of 1965. This provided massive new federal funding to schools, especially Title I aid for low-income students. Compliance with Title VI of the 1964 Act was a condition for receiving funds. The combination of the two acts gave the federal executive branch leverage to require desegregation plans before releasing funds, turning financial incentives into a de facto mandate. So, I mean, that's something that's been suggested with the, I guess, what do you want to call it? Remigration or mass deportation, whichever you want to call it. So basically, the federal government could force these sanctuary cities to basically submit a plan for them deporting all the immigrants. Otherwise, they can cut federal funds because they did that before. The U.S. Department of Justice, under Title IV of the 1964 Act, could file lawsuits to enforce desegregation in public schools and facilities. So I guess you could sue the schools, but that would be, I don't know. I guess you could sue the schools for taking illegal immigrants into the school, but I guess the kids themselves aren't illegal immigrants in a lot of cases. Okay, in extreme cases, e.g. Little Rock, Arkansas in 1957, the executive branch used federal troops or marshals to enforce court orders. Oh, court orders, but not warrants. So you can just use a court order without a warrant. Though this was rarer for schools broadly. Okay, schools, yeah, okay. This section states that all persons are entitled to the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of any place of public accommodation without discrimination or segregation on the grounds of race, color, religion, or national origin. The national origin thing is kind of weird, though. It defines places of public accommodation to include hotels, motels, or other lodging establishments, with a small exemption for owner-occupied homes with less than 5 rooms. Restaurants, cafeterias, lunch counters, soda fountains, facilities principally engage in selling food for consumption on premises, including retail stores, gasoline stations, motion picture houses, theaters, establishments physically located within or serving patrons of the above. Exemptions exist for private clubs or establishments not in fact open to the public unless they make facilities available to patrons of a covered establishment. Oh, okay. Of one of these other places. Unlike school desegregation, primarily enforced via the 14th Amendment, the 14th Amendment's Equal Protection Clause, and federal funding conditions, Title II's application to private businesses relies on Congress's power to regulate interstate commerce. Congress found that racial discrimination in these businesses burdened interstate travel. Okay, so if you can prove that it's causing some type of interstate problems, right, then that could be some type of grounds. It's pretty not, it's not the strongest grounds, but you know what I'm saying? It's like if you can, I mean, obviously this is burdening, I mean, it's not burdening interstate travel, but but like the taxes are a burden, interstate burden. If they're receiving federal funds, then that's an interstate burden. I mean, okay, it's not. Restricted the free flow of people and goods in commerce. Has substantial aggregate effects on the national economy. Okay, here we go. Had substantial aggregate effects on the national economy. Right, was one of the grounds that they used in order to bring in the federal government to enforce these laws on people, on the movement and free flow of people. Okay. The Supreme Court upheld this in 2 landmark 1964 cases decided shortly after the Act's passage. Heart of Atlanta Motel, Inc. v. United States, 1964. A unanimous court ruled that Title II was constitutional as applied to a motel near major interstates that served out-of-state travelers. Even though the motel was a local private business, its operations affected interstate commerce, so Congress could prohibit racial discrimination there. Okay, also unanimous. The court applied Title II to Ollie's Barbecue, a Birmingham restaurant that brought food, e.g. meat, shipped in interstate commerce and served mostly local customers. The court held that discrimination in restaurants collectively burdened interstate commerce, e.g. by discouraging travel and purchases, citing broad precedents like Wickard v. Filburn. The individual's restaurant's minimal direct impact didn't matter. Aggregate effects justified federal regulation. These rulings were confirmed that Congress should reach private local businesses under the Commerce Clause when their discriminatory practices substantially affect interstate commerce, even if no state law required the discrimination. Okay, enforcement mechanisms. Private individuals could sue for injunctive relief, court orders to stop discrimination. The U.S. Attorney General could file suits, especially for pattern or practice cases, or intervene in private actions. No direct federal funding cutoff was involved, unlike Title VI for schools programs receiving federal aid, but the Commerce Clause provided the direct authority over private commerce. This shifted from purely state-enforced segregation, Jim Crow laws, to federal prohibition of private discrimination in key public-facing businesses, dramatically increasing access for black customers nationwide in the years following 1964. True private entities, e.g., genuinely exclusive clubs, remained exempt. Okay. So, it looks like the only things that really apply here would be like the aggregate effects type of stuff and possibly interstate commerce too. Possibly interstate commerce. Because, I mean, obviously most businesses now do interstate commerce in some way, shape, or form. They're like, if this place is just receiving meat from another state was enough to basically take away their constitutional rights to discriminate, then the aggregate effects thing, where obviously the tax money, if they're using federal tax money, and also, I mean, I don't know, it's kind of hard to prove aggregate effects, but it does seem like, I don't know, because like saying that like depopulation is an aggregate effect, because some people could argue that, well, maybe white people just aren't having as many kids. Like, it's kind of like hard to prove that, because if somebody could just be like, well, it's not that they're having too many kids, it's that you're not having enough kids, and that's why it seems like depopulation. But I mean, in either case, it does equate to a replacement type of thing. Now, I don't know if that's enough, but it does seem like, especially going after businesses that hire, immigrants, undocumented immigrants, or, I mean, some people say any immigrants, but okay, in either case, if they're doing interstate commerce, then that opens them up to the feds. And definitely, there should be no qualms with cutting funding to schools, because they were going to do it. They did it before. Created strong financial pressure. So, well, like I said, we can see that those are some of the techniques they use. I mean, I'm sure if you keep searching, there'll be a lot more. I don't want to make this video too long, but that's kind of the idea of what I'm talking about here, is that, because I think the desegregation thing is more like in context, because it has to do with, the movement of people, and how that's affecting the population. So it's kind of interesting, because you can even argue this too, that, people, it's burdening interstate travel, because people don't want, you could say, oh, well, people don't want to go to Minnesota now because they're afraid, because there's higher crime or some other type of thing. Well, obviously now, because there's riots, I wouldn't want to go to a riot state, but, these things could be explored, definitely, as justifications for a more firm federal hand in removing, especially illegal immigrants. So, yeah, that's the video. Thanks for watching if you did. Have a good day and peace.